Chapter 10 Labor Management Relations. A labor union can be defined as an organization of employees that uses collective action to advance its members' interests in regard to wages, benefits. Three categories of employees. Number 1, managerial employees. Number 2, supervisory employees. Number 3, rank and file employees. Labor organization is established principally for collective bargaining purposes. Workers' association is organized for the mutual protection of its members but not for collective bargaining process. We have labor regulations.
Refer to that part of labor law which regulates the relations between employers and workers.
Labor standards.
Minimum terms and conditions of employment which the employer is required to grant to its employees.
Labor organization.
Association of employees which exist in whole or part for the purpose of collective bargaining.
Legitimate labor organization.
Organization duly registered with the Department of Labor and Employment or DOLE.
National union or federation.
Alliance of a group of unions in one industry in any area, region, or country.
Exclusive bargaining representative.
Labor organization duly recognized or certified as the sole and exclusive bargaining agent of all employees in the bargaining unit.
Collective bargaining.
Management and union set the terms and conditions of employment.
Collective bargaining agreement.
End result of a collective bargaining.
Labor disputes.
Questions or controversies regarding terms and conditions of employment.
Arbitration.
Final stage in the dispute resolution process.
Strike.
Concerted action of employees as a result of an industrial or labor dispute.
Lockout.
Temporary refusal of any employee to furnish work as a result of an industrial dispute.
Labor arbiter.
The hearing officer of the National Labor Relations Commission.
Union security agreement.
Contractual agreement usually part of collective bargaining agreement.
Types of labor disputes. Rights disputes. Interest disputes. Labor standards disputes. Labor relations disputes. Welfare and social legislation disputes. Who may join unions? All persons employed in commercial, industrial, and agricultural enterprises, including religious, charitable, medical, or educational institutions operating for profit. Labor organizations in the Philippines. Number 1, Trade Union Congress of the Philippines, 2 UCP, Partido ng Manggagawa, PM, Alliance of Progressive Labor, APL, Bukluran ng Manggagawang Pilipino. Different models of settling labor disputes. Negotiation
Is a process in which two or more parties resolve a dispute or come to a mutual agreement.
collective bargaining.
Is the negotiation process that takes place between an employer and a group of employees when certain issues arise.
Grievance machinery.
Includes all dissatisfaction that arise in an organization whether unionized or not.
Mediation
Is a voluntary process in which an impartial person or the mediator helps with communication and promotes reconciliation between the parties which will allow them to reach a mutually acceptable agreement.
conciliation.
The practice of bringing together the parties in a dispute with an independent third party so that the dispute can be settled through a series of negotiations.
Arbitration
Ultimate legal remedy of any dispute. Under this method, the disputes are settled in reference to adjudication by the government.
voluntary arbitration. Compulsory arbitration. Forms of union security. Closed shop. Union shop. Agency shop. Open shop. Dues check-off.
When there is an impasse, any of the following might take place.
Strike. Injunction. Lockout. Picketing. Third-party intervention. Chapter 11. Basic labor law affection. Employer and employee relationship. General labor standards. Minimum wage.
The computation of the estimated equivalent monthly rate.
Premium pay.
Additional pay provided to employees for working certain types of hours.
Right to holiday pay.
Payment of the regular daily wage for any unworked regular holiday.
Regular holidays.
Every employee is entitled of
Overtime pay.
additional pay for work performed beyond 8 hours a day.
Night shift differential.
Additional 10% compensation to the regular wage of an employee for each hour of work performed between 10 p.m. and 6 a.m.
Computation of wages.
Is governed by rule.
Right to service incentive leave.
Every employee who has rendered at least a year of service is entitled to this leave of 5 days with pay.
Paternity leave.
Allows the husband to lend support to his wife during her period of recovery and in the nursing of her newborn child.
Maternity leave.
Every pregnant woman, whether married or not, is entitled to this leave of 60 days in case of normal delivery, abortion, or miscarriage, or 7 to 8 days in case of cesarean section delivery.
Parental leave for solo parents.
Granted to any solo parent or individual who is left alone with the responsibility of parenthood to enable him or her to perform parental duties and responsibilities.
Leave for victims of violence against women and their children.
Granted to private sector women employees who are victims as defined in Republic Act No. 9262.
Service charge.
Employees of employers collecting service charges are entitled to an equal share in the 85% of the total of such charges except managerial employees.
Separation pay.
Given to employees in instances covered by Articles 283 and 284 of Labor Code.
13th month pay.
All employers are required to pay their rank-and-file employees regardless of the nature of their employment and irrespective of the method by which their wages are paid provided.
The workers' basic rights. Equal work opportunities for all. Security to tenure. Work days and work hours. The normal hours of workday are 8 hours. Weekly rest day. Wage and wage-related benefits. Payment of wages. Employment of women. Employment of children. Right to self-organization and collective bargaining. Attached agencies are Employees Compensation Commission, ECC, Institute for Labor Studies, ILS, Maritime Training Council, MTC, National Conciliation and Mediation Board, NCMB, National Labor Relations Commission, NLRC, National Maritime Polytechnic, NMP, National Wages and Productivity Commission, NWPC, Occupational Safety and Health Center, OSHC, Overseas Workers Welfare Administration, OWA, Philippine Overseas Employment Administration, POEA, Technical Education and Skills Development Authority, TESDA. Department bureaus are Bureau of Labor and Employment Statistics, BLES, Bureau of Labor Relations, BLR, Bureau of Local Employment, BLE, Bureau of Rural Workers, BRW, Bureau of Women and Young Workers, BWYW, Bureau of Working Conditions, BWC. Chapter 12, Employee Relations and Employee Discipline. Discipline is something that can only be imposed after an act of misconduct has already occurred. But managers and supervisors can use strategies to prevent misconduct before it occurs. Categories of difficult problem employees. Ineffective employee with unsatisfactory performance. Rule violators. Illegal or dishonest acts with personal problems. Substance abuse. Approaches to discipline. Hot Stove Rule by Douglas MacArthur. Progressive discipline. Positive corrective discipline. Negative approach. Preventive discipline. Counseling approach. The disciplinary process.
Informal talk, verbal warning, verbal reprimand, written reprimand, suspension, demotion, and discharge or dismissal.
Due process.
Mechanism that ensures both rights of management.
Substantive due process.
Provides the ground for disciplinary action.
Procedural due process.
Provides the procedure on how to get about hearing the side of the employee and evaluating all facts and evidences against the allegation.
Grounds for an employee to question the dismissal.
Based on substantive or procedural grounds, substantive aspect pertains to the absence of a just or authorized cause supporting the dismissal. Procedural aspect refers to the notice of termination or the opportunity to present an explanation.